Good morning and welcome to the Essential Construction Law Update webinar, which Building is hosting this morning in association with specialist construction law firm Fenwick Elliott. I'm Sarah Richardson, the editor of Building, and I'll be your chair this morning. With me, I have two expert speakers from Fenwick Elliott, Jeremy Glover, who's a partner in the firm and an accredited adjudicator. Jeremy advises on all aspects of projects from initial procurement to dispute avoidance and resolution and acts across a wide range of construction sectors in the UK and internationally. With Jeremy, we have Jatinder Garcha, a senior associate at Fenwick Elliott. Jatinder has over 10 years' experience in non-contentious UK and international construction work. So the aim of the webinar this morning is to give you insight into recent legal changes and developments affecting construction. We're going to hear presentations on three key areas. First of all, an update on the judicial process and procedures from Jeremy Glover. Then Jatinder will give a legal view on the construction supply chain payment charter. And then we'll go back to Jeremy for an update on BIM. The presentations will all be about 15 minutes each, and we'll have some time for questions at the end. You can ask a question at any time, and I'd encourage you to do that. You can do that by typing in the box beneath the slide window that should be appearing on your screen. So without any further ado, I'm going to hand over to our first speaker, Jeremy Glover.
Thank you very much, Sarah, and hello to everyone who's listening in. As Sarah said, we wanted to start by having a look at sort of recent, what we've termed as judicial approaches, but more specifically what we want to talk about is ways of making and resolving your claims, perhaps by staying outside of the courts. It may sound surprising to say this, but even as lawyers, where we can, we want to do our best to help keep disputes out of the courts. So we really wanted to start today by having a quick look at the latest developments in two of the outside of court processes, developments in alternatives to litigation, mediation and adjudication. So you can see on the slide, I want to start by having a look at mediation and then talking about what's been happening over the last 12 months, but also acknowledging that the press and from the courts over the last 10 years has been to encourage parties to mediate. It was 10 years ago that the Court of Appeal first started to effectively penalise parties who they considered unreasonably refused a genuine request to mediate. And you'll see on the current slide a quote from Lord Justice Dyson, who was a member of the Court of Appeal at the time, and it's specifically it's quite important for the construction industry because Lord Justice Dyson was one of the judges from the TCC, the construction courts. And you can see the words at the end of the slide. He makes it clear that the form of encouragement from the courts may well be robust. That is, encouraging parties to mediate. And I think it's worth just considering some of the factors that may be relevant to any decision to mediate. And by mediate, I mean some form of structured settlement approach which is chaired by an independent third party. Now, the things that the court will look at are the nature of the dispute, the merits of the case, the extent to which other settlement methods have been attempted. They'll have a look to see whether the cost of the proposed mediation scheme would be disproportionately high. And they'd have a look to see whether there's been any delay in the setting up of the mediation. What's the timing that's been proposed? And finally, they'll look to see whether ADR had any reasonable chances of success. Now, I want to have a few comments about this, and I'll be taking as a benchmark two cases from the last 6 months. One's the Garrett Critchley case, and one is another case from the construction courts, which involved NGM and British Aerospace. And firstly, looking at the merits of the case, I think it's fair to say that the courts consider that most cases are suitable for mediation, but sometimes you'll find a party will say, well, my case is so strong, I'm going to win. There's no point in having a mediation. It will just unnecessarily cause a duplication of unnecessary costs. Now, the view of the courts is clear. you must have a very strong case, not a borderline case, and the tests that the courts will apply is whether or not that your case is suitable for summary judgment. That is where the court will enter judgment in your favour just by considering the issues on paper. It won't look to cross-examine witnesses, and it means that you've got an overwhelming chance of success. So it's very unlikely that you can say to a court that I was justified in my refusal to mediate because I had a strong case. The court will say if you had a strong case, you should have applied for summary judgment. Another issue is timing. And that's quite important actually, because there's no point saying I want to mediate when you've got 2 or 3 weeks to go before the trial. No point saying that for the first time. One reason for that is because you've already incurred a significant amount of costs in running your case up until the doors of the court. The other reason, from a reason of whether it's not reasonable to decline the request to mediate, is that the other party will say, well actually there isn't really time. I've only got 2 weeks to go to my hearing and I need to properly prepare, and the courts will accept that. Now the other consideration is, well, shouldn't you have tried to mediate some time ago? If you look at the construction pre-action protocol, which sets out the procedures that parties must undergo before they actually initiate the court process, that makes it clear that there should be a meeting between the parties and that the parties should explore whether some form of alternative dispute resolution meeting should be attempted now before the parties are actually locked into a dispute. And I think that's a very valuable sentiment, and there are clear advantages to parties, provided they have enough information about the dispute, to look to see whether they can resolve the dispute at a very early stage, before everyone starts spending lots of money and before everyone starts hating each other because they're locked in an adversarial process. Trying to mediate your dispute early is often a very good idea. And you can always try other settlement methods. You can have ordinary face-to-face meetings. Maybe you want to sort of instigate some form of structured offer. And you should always remember that the courts will never consider that the costs of a mediation are disproportionately high. And that's disproportionately high when you take into consideration the overall costs. In the NGM case, the overall costs were estimated to be some £500,000. The costs of the mediation, although they might seem high at £40,000, were very small when you compare to the overall costs of the dispute. Another question that the courts will ask is whether the mediation has a reasonable prospect of success. The answer to that is almost always yes. In fact, the courts are at great pains, as you can see from the slide on the screen at the moment, to actually say that it's where parties are really far apart, it's where they pretty much hate each other's guts, that mediation can actually be a really good force to help settle a case. And the reason for that is you've got skilled mediators, you've got a skilled third party who can cut across the emotional obstructions to a settlement. So if you're faced with an offer to mediate, what should you think about? What steps should you actually take from a practical point of view? Certainly you should always respond promptly to an offer to mediate. One thing to bear in mind is the one reason to always think about mediation is that it might well work. The settlement rates from CEDA, who are the body which is primarily responsible for mediations in the UK, suggests that 75% of all mediations achieve a settlement on the day, and a further 11% settle within a few days of the mediation. So always be open-minded. You never know what's going to happen. And if you're prepared to be mediate, to what you want to mediate, be proactive. Make sure that the people who can make decisions are available. If you need more information from the other side to properly understand part of their claim, to understand how the quantum is broken down, ask for it. Always keep a record of events just in case you need to justify the steps that you took. And don't sit on your hands. Don't say nothing. Silence isn't an option. You must at least explain what you're doing, and explain what you're doing at the time. You can't come back and sit in a courtroom 18 months later and say, well, this was the reason I didn't mediate. You need to be open at the time, and never close off the possibility of mediation. Always bear it in mind. When's the right time for you? And of course, mediation is only one form of ADR. ADR is alternative dispute resolution. Another form of ADR, it might sound slightly surprising, is adjudication. I just want to spend a few minutes now just some of the latest cases from the courts. I'm going to make three sort of key points. The first is that if you're challenging an adjudicator's decision, you're resisting enforcement of that decision, nothing has really changed in terms of the construction court's basic overall approach over the last 12 months. The way I always look at it, and this actually before having read the decision which someone wants to challenge, always assume you're 1-0 down before a file has been opened. So it's quite difficult to resist an enforcement of an adjudicator's decision. One important thing to remember is if you're going to court to resist that adjudicator's decision, remember what your contract says about challenging the adjudicator's decision anyway. Under the NEC 3 form of contract, if you don't file a notice of dissatisfaction within 4 weeks of the decision, that decision becomes final. And that becomes final even if you've gone off to court to challenge enforcement of the adjudicator's decision. And that's what happened in the case that's on the screen for Manor District Council and Gibson. The judge said that it was a high-risk strategy of ignoring the adjudicator's assessment and then going off to court without having given the actual formal notice that was required by the contract. And the other case that I just want to mention briefly was actually one that was reported and released by the construction court at the end of last week. And it involved a dispute between Eurocom and Siemens arising out of the development of some communication systems at Charing Cross and Embankment Underground Station. Traditional disputes arose concerning delay to the commencement of work, variations, prolongation, disruption costs, nothing out of the ordinary. About 12 months ago, there was an adjudication, and Eurocom were awarded a small amount of money by the adjudicator. About 12 months after that, Eurocom put forward another formal claim document, and this wasn't accepted by Siemens, and Eurocom went off to adjudication. And what's particularly interesting about this case is that the steps that Eurocom took in initiating the adjudication process. With most adjudications, you serve your notice of adjudication, and then you apply to an adjudicator nominating body and ask that they appoint an adjudicator. I think it's fair to say that the majority of adjudications in the UK are sort of run, well, not run, the adjudicator is appointed via the RICS, and they have a 2 or 3 page form that you have to fill in. And one of the questions asks whether there's any adjudicators or potential adjudicators who would have a conflict of interest in the case that's being sought. And if there is such an adjudicator, then the party filling in the form is asked to give details. And this is what Eurocom's representatives did. And they filled out the form, and they advised that approximately 11 people and 1 law firm shouldn't be appointed as acting as the adjudicator. And they gave a number of reasons. One adjudicator, there was a dispute about fees. Another, there was a question of apparent bias. They didn't want the first adjudicator to be appointed. And then they said that Fenwick Elliott shouldn't be appointed because we had advised the referring party. That was, in fact, an error, and it should have been another firm of solicitors. But what happened was that Siemens actually said, well, you haven't actually filled out that form properly because none of the adjudicators or individuals you've referred to, there's no conflict of interest. You're actually saying they're potentially biased. So the matter went to the courts, and the court asked for an explanation as to why these individuals had been named. And the court wasn't particularly impressed by the answers, and it appeared, I say no more, that perhaps some of the names on the list, particularly the first adjudicator, who hadn't given a decision that was particularly favourable to the referring party, they'd been named to try and avoid the RICS actually appointing them. And that's particularly important in relation to the first adjudicator, because the RICS policy is usually to appoint the same adjudicator on similar disputes, because it saves time and it saves money. And the net result of all this was that the adjudication decision was not enforced. The court said that if a party fails to follow the correct adjudication process, fails to fill out the form in a proper and fair, balanced way, that's a matter that goes to the heart of the appointment. And then if that happens, then the adjudicator does not have jurisdiction. In other words, the court's saying you've got to take care not to skew the system. And that's I think this is quite an important decision, and it is a clear statement of support by the courts for the adjudication process, and it's a clear statement by the courts that it expects the adjudication process to be carried out in a fair and transparent and balanced way. So be careful when you're filling in these nomination forms, and be honest when you're doing so. Otherwise you may find at the end of the day that the adjudication decision is not enforced. Of course, I suppose it might be said that if everyone was using the building supply chain payment charter, then maybe there would be fewer disputes. But that's something that my colleague Jatinder Garcha is going to be talking about more.
Thank you very much, Jeremy. Really interesting presentation. Just to remind you, if you have any thoughts on the points that Jeremy made there, you can ask a question at any time on the box on your screen, and we'll come to those at the end. But now I'm going to hand over to Jatinder Garcha, who will give his view on the construction supply chain payment charter.
Thank you, Sarah. Good morning, everybody. Just a very quick introduction and background to the charter itself. So in July 2013, the government launched its construction its Construction 2025 industrial strategy, which was aimed at producing a long-term improvements in the UK construction industry. As part of that, it set up what it called the Construction Leadership Council, which was established to take forward the strategy and also the Construction 2025 Industrial Strategy objectives. Now, the CLC itself is comprised of 30 members from all parts of the construction industry, including employers, contractors and specialist groups, and was responsible for developing an action plan, and with a goal to develop a construction payment charter in conjunction with the Institute of Credit Management. Now, this charter itself was officially launched on the 22nd of April of this year, and is aimed at combating abuses in the industry in respect of payment terms. The charter itself contains 11 commitments. I haven't put all of them on the screen, but just picking out some of the more important ones, which is meant to apply to the whole supply chain. First and foremost, payment terms of 60 days are to apply to all contracts, new contracts from January 2015. Payment terms are then to reduce to 45 days from June 2015 and eventually to 30 days from January 2018. There's an ambition, and unfortunately that's all it is, an ambition to move to a zero retention by 2025. There's the increased use of project bank accounts, in particular on central government projects. And probably a point that's missing off, and I should really have included, was that there's also a commitment to make correct full payment as and when due in accordance with the contract. So how is the charter intended to work? The Charter itself is not a contractual document, and I'll come on to the effects of that in a little bit later in this talk. But the signatories are to apply a fair payment commitment in their dealings with the supply chain. Now, signatories to the Charter are monitored by compliance by reference to a set of key performance indicators, or KPIs. It being intended that the KPIs, the performance against the KPIs, is to be considered when awarding new contracts. So that was just generally the very quick background to the Charter itself. Now, the Charter is unquestionably a well-intentioned and necessary, as it is quite widely reported that some parties within the supply chain are having to wait 60, 90, and even 120 days for payment, which obviously has a huge effect on cash flow and potential insolvency as well. Now, unfortunately, just the Charter itself has only recently been issued, and therefore there are, at this stage, probably more questions than answers. And what I was trying to intend to do in this part of the talk was just to raise highlight some of the issues that we perceive with the Charter, which hopefully in time will be answered. Now, first and foremost, it's to be pointed out that the Charter itself is only voluntary commitment only. And unfortunately, at this stage, from the 30 CLC members that I alluded or commented on earlier, only 9 of those that have themselves signed up to the Charter. The question is, if it's only voluntary to sign up, then what is the incentive to sign up? Now, again, the first question is it intended that the government and also public sector bodies will not use contractors on public projects if they have not signed up to the Charter? Now, that's hopefully the intention, but that's not quite been made clear at this stage. Or is it just hoped that the main contractors will sign up anyway voluntarily for fear of losing specialist subcontractors to other contractors that may pay on better terms? Now, the next issue, I suppose, is even if firms have signed up to the Charter voluntarily, what is the enforcement rights and what are the sanctions for failure to comply? Unfortunately, as I said earlier, the Charter is not a contractually enforceable document. So it's around this issue of sanctions and enforcement, I suppose, that I'm most interested. First and foremost, if a supply chain member wants to have a contractual recourse under the terms of their engagement, then what does that mean? Does that mean that if a main contractor or an employer, for that instance, is willing to voluntarily sign up to the Charter, will they be amending their terms and conditions to reflect this? Are we going to see amended terms and conditions being proposed by contractors and employers? If not, what does that mean? Will someone further down the supply chain be entitled to propose amendments to the contract to reflect the Charter? Well, as I say, as a non-contentious construction lawyer who deals with drafting of contracts, I look forward to seeing what will happen in that respect. Also, even if such wording is included or secured within a contract, will the terms actually be enforced due to the risk of alienating perhaps the employer or the Tier 1 contractor for future projects and future work? Another drafting point, as I would put it, some of the commitments within the Charter themselves are fairly vague. So the actual meaning of the commitments is obviously, again, something that's going to have to be fleshed out in the contractual terms. And again, that's another area of potential future the negotiation, I suppose, and contract amendment. Alternatively, are we likely to see new drafting proposed by Tier 1 contractors or employers effectively trying to sidestep the Charter, even if they've signed up to it voluntarily? Again, all questions relating to drafting, I think we will have to just wait and see what happens in that respect. Next point to make is what are the sanctions if parties are not complying with the Charter if they've voluntarily signed up? Well, that also itself needs to be considered further. How do you enforce if there is no accompanying legislation? What is the intention? Are the government intending in the future, as part of their construction strategy, to introduce at some point in the future some legislation to either build further upon the 2013 amendment to the Late Payment of Commercial Debts Act, or are we even considering some sort of amendment to the Construction Act to introduce a long stop to the final date for payment? Again, nothing we at this moment in time have any view on, but hopefully we shall soon. Or is it intended that the only sanction will be the data will be used to prevent non-compliant firms from undertaking public sector work? The third point on this slide at the moment is there's a commitment under the Charter that effectively states that the employer or the main contractor, whoever, will make payment in accordance with the contract, in accordance with its terms, fully. Now, as a commitment, it seems almost unnecessary for there to be that kind of commitment, because surely full payment is already covered by the Construction Act itself, and also, why would you need to sign up to a separate commitment to comply with the contract? Surely this should be done ordinarily anyway. As I said to you previously, unfortunately, we are unable to fully assess the Charter at this moment in time, in particular because the KPIs themselves have not yet been finalised. Now, the latest position on the KPIs is set out in this slide, and effectively, as I say, the monitoring arrangements are still being finalised, with a full set of reporting requirements to be agreed by the end of the year. What has been agreed at this stage is a broad agreement on 4 KPIs, which are payment days in, payment days out, proportion of retentions, and proportion of deals under supply chain finance agreements. Again, unfortunately, this doesn't seem to cover all of the 11 commitments. So hopefully the KPIs will be expanded to cover all of those as well. And then just one final point to make is that, as I say on my slide, the client must be show some sort of commitment towards the Charter. And I mean that in 2 respects. Firstly, they must be committed to agreeing to make payment within 30 days themselves. So employers and clients must have to sign up. But secondly, they must also ensure the main contractors that they employ are also committed to the Charter. In the public sector, this may be easier, and public sector bodies may be forced to have to use only contractors that are committed to the Charter, whereas it may be a slightly different issue within the private sector. Now, some commentators have stated that the Charter commitment may itself starve Tier 1 contractors of cash to support their operations. What that means is that major contractors will therefore need to find alternative financing, forcing them to increase their prices effectively to compensate for the loss of what they might think cheaper credit by holding on to money of supply chain members. Again, ultimately, if that is the case, then that is a point that will have to be picked up by the clients, as they will be the people that will have to pick up the ultimate cost of that. And the question is, in the private sector, is that something that will be acceptable? Now, as I say, just to finalise, as stated, the Charter is certainly well-intentioned and welcome, but there are a number of questions, in particular around enforcement and sanctions, that still need to be worked out. So at this stage, we will just have to wait and see what happens.
Thank you very much, Jatinder. Really interesting presentation. Just to remind you, we've had some questions start to come through now, so if you do have those that you want to add to the list, then do type them into the box at the bottom of your screen. And now I'm going to hand back over to Jeremy for the final presentation, and this one's on BIM.
Thank you very much, Sarah. And thank you to Jatinder. And of course, BIM is another key component of the government's construction strategy. And what we want to look at briefly is where we are going now with BIM, and the short, simple answer to that is that the government is pressing on with the adoption of level 2 BIM on all government projects by 2016. And the answer to where are we going, well, I think it's really where the technology takes us to level 3 and beyond. As the technology advances continue, then people need to adapt to the changes, and the reason that we need to adapt to the changes is because of the benefits that BIM and associated approaches can bring to the entire construction process. And I think one of the key things that people are beginning to appreciate about the whole BIM process is the focus on commitment from the client and the focus on the early engagement of the client in the entire construction process. I think that's key to the establishment, the involvement of BIM on any project. And it all part of the cooperative approach that I think BIM demands. Now, of course, BIM raises a whole variety of interesting and difficult questions about responsibility if things go wrong, and there's a whole host of issues that I've highlighted up on the screen. I've only got 15 minutes, so what I'm going to focus on is the area of BIM that I think that's had the most exposure recently, and it's the end of the project. It's the end of the contract. And I suppose it's not surprising that it's only now that that's where the focus is, because the projects that initially were started with BIM are now coming to an end. And of course the other reason why it's so important is this is where the government has identified the real savings, the real cost savings. I think the government has said that use of BIM and its related components will lead to overall savings of some 15 to 20% of the costs of capital projects. And that most of those savings actually come right at the end, when the building is actually being used. So that's what I want to focus on, what's happening at the end of the project. Now, people have come up with lists of what are the key components of level 2 BIM. And these are the, well, until I was going to say 7. Until 2 or 3 months ago, I thought there were only 7 components of level 2 BIM. It now appears that there are 8. The new one is the PAS 192-5, the one that deals with security-related issues. That's data security-related issues. Now, I suppose one of the questions that people might ask in their minds at least is that there's a list of 8 components. They're all to do with level BIM, and we're all supposed to be using level 2 BIM on government projects by 2016, and at least 3 of the 8 components are not yet available. That's just how it is, and that's not particularly helpful comment, I know, but I think what's important is that the will is there, and the will is there for 2 reasons. 1, because the government said so, and 2, because of the benefits to the project. But also 3 or 4 of these 8 components all relate to things at the end of the project. There's a British standard about the operational phase of the assets. It's not the construction phase, it's actually using the building. And things like the classification system, the common language, making sure that all the data speaks to each other and it's all understandable. That's incredibly important, because one of the key things about BIM is the amount of information and data that you collect as a part of the whole building information modelling process. And in particular, why that's important is because it relates to the government soft landings policy. And that's what I want to focus on for the next 10 minutes or so. And what do we mean by government soft landing? Well, at a simple level, it's all about the facilities management. It's all about the operations of the building. It's all about the maintenance of the building. It's what happens to the building once practical completion has been achieved. We're all used to the standard way you reach practical completion. As part of the obligations of practical completion, the contractor will produce its as-built drawings, and it will produce health and safety files and operations manuals which set out how all the things that are in the building, how they all work. And there's a bit of a cut-off, and that's that. By soft landings, I think what the government's really saying is that you don't have this cut-off. The whole process goes on a little bit further. And I know BIM is very, people who use BIM, there's a whole list of new technical terms, acronyms that everybody needs to learn. And with BIM, during the construction phase, you get something which is called record BIM. And that's all the data that's being used, that's being collected, that's part of the models that are being used for construction. And you put all that together and you get what's called PIM, the Project Information Model. And that's the information that is absolutely key for using the asset, using the building once it's been finished off. And that's really the basis, and that's the focus of the whole idea behind the government soft landings project. Now, I suppose the one difficulty I have with this, the one difficulty I have with all the focus that's in relation to this, is why has no one thought of this before? Because it makes a whole lot of common sense that if you're going to be running the asset, you want to make as much use as you can of the information that's being collected during the creation of that asset. And I suspect it has been thought of before. But I think the thing with BIM is that BIM has brought the process to life. It makes it more easy to use, and you can use, it's got this bundle of information, and that's the difference, and that's why there's now such a stress and focus on the GSL policy. Of course, the other focus is the stick. GSL is supposed to apply to all government projects from 2016. And the basic key is the extended aftercare period. Technically, and it's up on the slide, it's the post-construction proving of the asset by the contractor for a period of 3 years. Now, that's a bit longer than your average standard defects liability period. And I think that's one of the more important questions that need to be considered when considering the GSL process. How is it actually going to affect traditional completion, takeover? How is it going to affect the warranty period? But the three key factors as far as the government are concerned in the GSL policy, three: social outcomes, economic outcomes, environmental outcomes. Now, Jatinder was talking about KPIs earlier in relation to the payment charter. Effectively, there's the possibility here to set up KPIs in relation to bits of the building, functionality, how does the air conditioning work, what are the carbon emissions if there are any. The whole key is to identify and maybe reduce operational and capital costs. You're looking at, I suppose in simple terms, obtaining customer satisfaction, meeting environmental goals, but the way to do that is to set clear and measurable targets for these outcomes. And the only way you can do that is by having clear and early engagement with the end user, the person who's going to hold the asset at the end of the project. It's no good halfway through suddenly saying, well, actually, when this building's finished, it's going to do X, Y, and Z. Because if you haven't already thought about what X, Y, and Z are, that means change. That means variations, that means cost, that means delays. So the whole point endorsing the GSL policy, you must engage at the beginning with whoever's going to be using the building. Now, the good thing about the GSL policy is that it closely aligns with the RIBA plan of works. The RBA plan of works is in 8 stages, from stage 0, the strategy, through to stage 7, operations. But the important thing is that you don't just use the last 3 or 4 parts of the RIBA plan of work, the handover closeout operation. You think about using the building as part of the strategy, as part of the brief, the concept, engage with the people who are going to run the building at the time. And then you have a new role, the GSL champion. This is someone who is supposed to be around, be available throughout the project, to maintain the focus of all parties on the required project outcomes. Now, that sounds like quite a sensible idea, because you need to have someone who's there, who's thinking ahead, what's going to happen at the end of the day. With my lawyer's hat on, it also sounds like a potential recipe for trouble, as you can see that the GSL champion, there's a danger that they're going to interfere. There's a danger that they're going to be saying, change this, do that, and they won't be doing it through the actual contract procedures. So there's a risk point with the GSL policy. Make sure there are some reins on your GSL champion as to what the GSL champion can do and what the GSL champion can't do. And then you need to clearly define. We talked earlier about the outcomes. How are you going to measure performance? And I hesitate to say it given the collaborative nature of the whole BIM process. Are you going to penalise performance if it falls below the outcomes that are required? And this is where I think the whole GSL policy, the whole GSL approach, some care is needed. You need a clear contractual definition of who is going to do what and when they're going to do it. Because with GSL, you're cutting across the contractual, strict contractual way of doing things. I've already said defects liability period, 6 months, 12 months. You release the retention half at practical completion, half at the end of defects liability period, but you're expecting the contractor to stay on through the project for an extra couple of years. And you're expecting the contractor to come back and hold review meetings and to prepare reports. Now, it's actually a really good idea, because the best person to see if there's a problem with the building is the person who built it. And most normal, sensible people, it's what they do every day in their jobs. They'll sit down with everyone and they'll try and sort out the problems. But like anything, if there's a serious problem, then difficulties can arise. And that's what a contract's for. It's for having a clear way through the dealing with problems. And the only way to do that is to have clear goals, clear specifications of what is supposed to be achieved. And that's why I'm slightly nervous of the alternative to the GSL approach, which is the approach by the Building Services Research and Information Association. Their approach is up on the screen, and it's much, much more collaborative. And what they're really advocating is encouraging parties to operate in a frank and open manner and requiring them pretty much to agree not to sue each other except in limited circumstances. Now, I'm all for people operating in a frank and open manner, and there are clear disadvantages in suing each other, but you need to be careful. You can go too far in this collaborative open approach. And I think the way to make GSL work is to set boundaries, set guidelines. GSL is not largely a technical issue. You need carefully thought out contractual arrangements. One of the key tenets of the GSL is the greater use of outcome-based specifications but you need to be able to set them against clear performance criteria so that there is some kind of objective standard to judge them against. Now, the minute I start talking about that, there will be alarm bells being rung by designers, and there'll be alarm bells being rung by insurers as I'm edging towards fitness for purpose. And that is perhaps a topic for another webinar. But it's an example of things that people need to think about and think through. And that's why you need the early, clear engagement at the beginning of the project. And that's where GSL fits in perfectly with the whole ethos of BIM, the whole BIM approach. BIM is a more collaborative way of working. And because it's more collaborative, it requires and demands the early engagement of everyone. It's a combination of technology. It's the use of existing experience. And there's where the BIM, GSL, there is this so-called cultural step change. But I think the key for BIM and the key for GSL is always what does your contract and what does the scope of services say? Who is required to do what and when are they required to do it by? And whatever form of contract you've got, whether you've got a traditional form of contract or you're going for the more alliancing-based collaborative approach, you need that, otherwise you're going to fall down. And the other key thing, particularly with the GSL approach, is the early involvement of the owner and the end user of the building. But this, the government soft landings policy, don't get me wrong, it's a good idea. And it's an example of using BIM and embracing the technological advances of BIM for the benefits of the construction projects as a whole.
That's great. Thank you very much, Jeremy. Now, we've had a lot of questions come in on all three topic areas, so I'm going to try and get through as many as possible with our speakers now. But do keep them coming using the box at the bottom of your screen. So, first of all, I'm going to go back to the subject of arbitration right at the start with Jeremy's first presentation. Question here, very briefly, Jeremy. When can an arbitration decision be challenged? What are the grounds? Are there any sort of very common ones that come up?
Yeah, I mean, there are a number of grounds for challenging what I think adjudication decisions. The most usual ground is that the adjudicator didn't have jurisdiction. By that I mean the adjudicator didn't do what he was asked to do. He may have answered the wrong question. He may also have acted in a way that was possibly unfair to one of the parties. He may have apparently not taken into account a set of submissions that were made, or he may not have given someone a fair opportunity to be heard. But the crucial thing to remember is you can't actually challenge the adjudication decision on the grounds that the adjudicator got the decision wrong. And that's the most frustrating thing for a party. They will come and they'll tell me, well, that's just wrong. But if he's answered the question that was put to him, it's very difficult to challenge.
Thanks very much, Jeremy. Now a question for Jatinder on the payment charter. I know you mentioned the vast amount of work that lies ahead in terms of drafting with the payment charter. We have a question here as to whether JCT or any other organisations have commented at all on whether they will include the charter in future contracts or given any sort of suggestion or indication.
Thank you, Sarah. As far as I'm aware, organisations like JCT or NEC, who are responsible for producing standard form contracts, haven't as yet made any commentary on this. And that's probably not surprising at the end of the day. The charter itself is only voluntary, so there is no incentive on organisations like JCT or NEC to comment and to incorporate provisions which, one, may not necessarily reflect what parties are or parties that use their contracts are actually doing at that moment in time. They're probably, and I think probably the wisest thing for them is to wait and see what the uptake is for the charter itself. Once it has been taken up by numerous entities, then perhaps to wait and see what drafting is proposed and by other organisations or by clients and contractors alike before they start to look into making amendments to their contract themselves. Again, one of the issues, as I said in my slides previously, was that some of the commitments under the are actually fairly vague. So it's going to take quite a lot of drafting to flesh out what is actually meant by those commitments, and then organisations like JCT must potentially wait and see what other people are doing and to see what's going on in the market. Unsurprisingly, most of the comments at the moment are being made by specialist trades, because obviously payment is an issue that is most close to their hearts. So most commentary at the moment is coming out from specialist trades rather than contract entities like JCT.
Thanks very much, Jatinder. Now going back to mediation, there's an interesting question here come in about the question of costs in mediation. So Jeremy, you were talking about the timing of bringing a form of adjudication to the table. Does the in an award on costs, would any delay in bringing the case to the table be considered if the losses incurred could have been limited if it had been brought more quickly? And the example that was given by the person that wrote in was, for example, if the losses are loss of rental income.
That, as they say, is a very good question. I think that at one level the answer is that if you've got an ongoing loss and you're entitled to recovery of that loss, then the way that the courts would probably look at it is that even if there was an extra 6 months because you was slow, or the other side was slow and they caused delay, you'd be entitled to those costs. I mean, the difference is the example that's been given is damages, and in a sort of blunt judicial way, you're either entitled to the damages or you're not. Now, there are court cases that have deprived the party of interest on damages that they're entitled to if it can be shown that they've unnecessarily caused delay in bringing the procedures. So looking at the example given, although you'd still get the rental, you might be deprived of interest in relation to that, but the court will actually look to see what the actual overall entitlement is first, and then it will take into account conduct to a limited degree in relation to interest, to a much bigger degree in relation to costs.
Thanks very much, Jeremy. And just staying with you, but moving on to BIM now. Another interesting question I thought here around the requirement on a designer to execute their duties with reasonable skill and care. The person that's written in would like to know whether BIM knowledge, so use of intelligent object modelling and 3D models, etc., would be expected to be part of the knowledge of the reasonable or average designer.
That's a very good question. I think it would be very difficult to argue in November 2014 that your reasonable, average, ordinary designer doesn't know anything about BIM, because you don't look at the specialist, a highly skilled designer, you look at the average. Now, if you think about it, 2 years ago BIM was much newer, and there may well have been an argument, well, I hadn't really heard of BIM, but the big better argument is my practice didn't really use BIM particularly. I think now, particularly given the widespread knowledge of people's BIM, and when I say widespread knowledge, I mean Building Magazine regularly features BIM in the magazine and on the website. Other journals are the same. From a legal point of view, people talk about it. It's very difficult to say that most people in my profession, when that profession is a design profession, weren't aware of BIM, and therefore I don't think it's an excuse that you can use. I think reasonable skill and care now must include some knowledge of the BIM process.
Excellent, thank you very much. And just staying with you for one more before we return to Jatinder. We've had a question, are there any known BIM cases in dispute to your knowledge? And if so, what are they mainly about?
As far as I'm aware, there's only been one case relating to BIM, and that wasn't in the UK, it was actually in the United States. And to be totally honest, I don't think it was really, if you like, a inverted commas BIM case. It was a traditional type of dispute where someone hadn't actually measured out the space properly, and so there wasn't room to fit all the piping in. And it's called a BIM case because it was an error in spacing by someone using BIM, but it could just as easily have been someone making the error on spacing using an actual 2D drawing on paper. In fact, arguably, I suppose the only reason it's BIM related is that there's less excuse for making the mistake because you're using the sort of the BIM approach. But as far as I'm aware, that's the only case.
Thank you, Jeremy. Now going back to Jatinder on payment, we've had a question here about the buy-in rate of employers and main contractors to the charter. I mean, you made a lot of points about, the fact that it is a voluntary charter. I mean, what's your view on take-up of this, and how widely will it be used in the industry?
I hope it will be used widely within the industry. Unfortunately, just looking at the statistics at the moment, I mean, the buy-in rate hasn't been very good since the charter was introduced. In fact, as I alluded to earlier, only 3 of the 30 CLC members themselves have actually bought into it. Now, as far as employers buying into the charter, I mean, I think employers have to try to understand what the charter will mean to them before they will look into buying into it. As I said previously in my slides, that there is a potential that the costs could go up and prices could go up now because the contractor is having to finance effectively these projects and have to get external funding perhaps because of not being able to hold on to subcontractors' monies and having retentions from subcontractors and what have you. So there is a potential that long term that will mean an increase in the cost to the employer. Now, are employers willing to buy into that? Hopefully so, for the benefit of the industry as a whole, but we would have to wait and see whether that is what will happen. And main contractors will only start buying in, I would have thought, once employers are buying into it, in order not for there to be some sort of mismatch between their obligations and those that they have to their subcontractors. The only one point I would make, even though it's not contractual, there is an incentive commercially on main contractors to enter into the charter. As I said earlier, if it's the case that they are no longer able to get subcontractors to work for them, specialist subcontractors, because those subcontractors are now going to work for other contractors who have better payment terms, then even though that's not a contractual mechanism, maybe that will be enough to make main contractors buy into the charter.
Thank you very much, Jatinder. And I'm going to try and squeeze in one more question very quickly, Jeremy. On BIM again, does the extended aftercare period affect designers' responsibility periods?
Another good question. I don't think it's going to affect the traditional, if you like, 6-year, 12-year period. It may have an impact on what is actually, when you define defects, what's a patent defect and what's a latent defect. But I think at the moment it's not going to affect the, if you like, the periods of responsibility that sort of designers have to use at the moment.
Thanks very much, Jeremy. Right, now that's probably all we've got time for this morning. So I'd just like to thank our speakers, Jeremy Glover and Jatinder Garcha, for their insight today, and to Fenwick Elliott for partnering with us, and of course to all of you for joining. The webinar will be available on demand on building.co.uk for the next 12 months, so you can look back at any of the slides that you might have missed. And you can also tweet and continue the discussion using the hashtag FEWebinar. So thank you all very much for joining, and have a good day.